Make to mention listing of this IA, my lord, filed on 4/4/2006, 2026, my lord. Had not been listed yet, my lord. Can be listed on Friday, my lord. For orders, my lord. In MSC appeal, my lord.
Okay.
Much.
Item number 45, Lordship. I am for the respondent, Lordship. And the pass out for the day. I have taken consent from the other side petitioners.
I am for the applicant, Lordship.
45. What is your name? What is your name?
Yes, Ali.
Heard Mr.
File of objection.
A.S. Ali, learned counsel for the respondent who prays for an adjournment. Also heard Ms. R.B. Bora, learned legal aid counsel, who does not raise any objection, hence the prayer is allowed. Let this matter be listed. 10th August.
Thank you.
Please, Your Lordship. Lordship, I beg to mention item number 27 of the daily list. I have taken consent from the other side. Lordship, I will be filing objection. The opposite party is not well, so he was not able to travel to Gauhati to sign the affidavit. So I stay some time. So let the matter be fixed if convenient for the court on 5th of August.
Objection in where?
Regular, the first.
What objection? In appeal.
In the IA, he want to
In
file a
IA, you will be
Yes.
filing.
and there is an interim order.
Okay. Heard Mr. F. Hariti, learned counsel for the respondent who prays for some time for filing written objection in the connected interlocutory application. Also heard Mr. B. Borwa, learned counsel for the appellant/applicant who does not raise any objection, hence the prayer is allowed. Let this matter be listed 7th of August. Any interim?
Yes. interim.
The interim order shall continue till next day.
Much.
May I please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 19. The matter will come on upper page, my lord.
19. You are for the applicant.
Yes, Lordship. F.A. Hassan on behalf of D. Chaudhary.
Heard Mr. F.A. Hassan appearing on behalf of Mr. B. Chaudhary, learned counsel for the applicants who prays for an adjournment. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the same. Hence the prayer is allowed. Let this matter be listed on 7th of August.
Yes, Your Lordship.
May please, Lordships. I would like to mention, my lord, for listing, my lord, one hearing matter, my lord, on last listed on, my lord, 8/5/26, my lord. Matter pertains to, my lord, in the year 2022 matters. my lord.
Hearing
Order, my lord, order column, my lord. Order column.
10th August.
Obliged, my lord.
Episode.
And on other, sorry, sir. And other matter, my lord, on one item 47, my lord. This
Here.
hearing matter, my lord, there's a. I have
Today's
already-
list. Today's list.
Today's list, my lord. I would like to adjourn the matter, my lord. I've already informed and obtained the consent of the other side also, my lord. As my file has been misplaced, my lord, during the shifting of chamber, my lord, that's why, my lord, some problem. Otherwise, I was ready, my lord. But that's why I am here.
Heard Mr. S. Ahmed, learned counsel for the respondent who prays for an adjournment.
4 weeks, my lord. Please.
Adjournment on the ground that he has misplaced his brief file of the case. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment, who does not have any objection to the same. Hence the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
Obliged, much obliged.
Hello, I'm sorry, my lord. I just know my colleague has mentioned item 27, my lord. This matter maybe instead of taking on 7, my lord, can it be on 6th of August? 7 I'll out of station.
Okay, sixth instead of seventh, sixth.
I tell you.
Please, Your Lordship. I'm praying for listing of an RSA matter for orders on Friday, Lordship. There is emergency, Lordship.
Okay.
Apply, Lordship.
Thank you, sir. Thank you also for listing an alia also for releasing 50% order of our sir.
Twenty July.
May I please, Your Lordship. Lordship mentioned for listing of IA, Lordship.
What I?
IA releasing order of 50%, Lordship.
22nd July.
My please, Lordship, my lord, I beg to mention item number 4, your Lordship. May it be taken, your Lordship, the next week at any date, your Lordship. I have
Four,
taken the consent of other side.
four.
Four. Consent also taken.
Heard Mr. A. Devan, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed. 7th of August.
Give a bless.
Right, Mr. Lordship. I beg to mention listing of arbitration petition on Monday, the admission list.
Arbitration petition, what matter?
Lordship, I seek your pardon. I don't have the brief with me, but this notice was issued. It was last posted on 4th May.
Okay, on Monday. Okay.
Obliged, Lordship.
May it please your Lordship. Lordship, I beg to mention one IA civilian RFA listing for in order column.
22nd July.
Next.
May I please, Lordship. In this case, my lord, earlier petition was withdrawn, Lordship. My lord, it is a murder case, Lordship. A short date may be given, and a CD may be called for, Lordship.
Heard Mr. M.H. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Call for the case diary. Let this matter be
Today is
listed.
56 days.
29 July.
Today is 56 days, Lordship.
29.
Short date may be not named in the affair. Short date.
Before 29. 24th July.
Obliged, Lordship.
May I please, your Lordship? Lordship, earlier withdrawn, Lordship. So this is 482 BNSS application, your Lordship. Maybe, your Lordship. The FI is at page number 13, your Lordship. It is a long 5 pages FIR, your Lordship. So if your Lordship permits me without going through the FIR line by line, your Lordship, I'm trying to narrow down the facts in main allegations. What is in the FIR, your Lordship.
What is the allegation?
Yes, your Lordship. She elicits here she is the husband of wife of the petitioner, your Lordship. Now,
The first informant.
Lordship.
The first informant is the wife, your wife.
Yes, Lordship.
Okay.
Now, she alleged that, your Lordship, in the year of 2012, their marriage was solemnized, your Lordship. And after that, your Lordship, she caught red-handed, the husband, the red-handed, your Lordship, with another lady, your Lordship. That is one allegation, your Lordship. Another allegation is he is habitual drinker. And she is subject to physical and mental torture by all of the family members, including the husband, your Lordship, the petitioner, your Lordship. Again, your Lordship, she had been forcefully consumed anti-pregnancy pill in the year of 2012, your Lordship. The cause of action started from 2012, your Lordship. Again, your Lordship, she has, the petitioner has demanded dowry, your Lordship. That is in the year of 2012, your Lordship. Again, in the year of 2013, she has been directed to go to her parental place, your Lordship. That is the allegation in the year 2013, your Lordship. Again, your Lordship, 14, 15, 16, 17, nothing, Lordship. Again, in the year of 2020, March, your Lordship, again, she got pregnant, your Lordship. because of her forceful assault, your lordship, the husband's sexual assault, she got miscarriage, your lordship. Again, in the year of 2021, your lordship, because of all these tortures, she left the matrimonial house. That is the allegation in the FIR, and beautifully narrated with the help of some advocate, your lordship, this FIR, your lordship. Now, your lordship, what they lacks, your lordship? Why the delay, your lordship? Because here, your lordship, 14 years delay, your lordship. The marriage was alleged to be solemnized, your lordship, in the year 2012, your lordship. Now, 14 years delay has not been, lordship, elaborated, your lordship, in the FIR. Even, your lordship, here preliminary inquiry has been conducted by the IO, your lordship. In the preliminary inquiry report also, your lordship, at page number 21, your lordship, the delay part has not been there, your lordship. Now, what is the real fact? Now, before this, your lordship, what is the section booked against me, your lordship? That section, your lordship, 296, your lordship, 85, 351.3, 82.1, and 89 of the BNS, read with section 3 and 4 of the Dowry Prohibition Act has been booked against me, your lordship. Now, what is the real fact, your lordship? There is no marriage, your lordship, in between the petitioner and the informant, your lordship. Yes, I admit, your lordship, there is a love and relationship between me and the informant, your lordship. She started to reside in my house for 3 months, sometime in a year, your lordship, 5 months for a year, sometimes in a year, your lordship. That is true, that is admitted. It was in the year of 2017, your lordship. And in the year of 2019, she left my place, your lordship, because her observing antisocial behavior and aggressive nature, your lordship, my family suggested me not to marry her, your lordship. And with due respect, I convey the message, your lordship, to her. But see, your lordship, on the contrary, your lordship, see, lordship, take it as a revenge, your lordship. If lordship may kindly see one certificate issued by the Gram Pradhan, your lordship, at page number.
When the FIR was registered,
It was in the year 2000, June, your lordship, 2026, your lordship.
now why are you apprehending arrest now?
Lordship,
Why are you apprehending arrest?
because my name is there in the FIR, your lordship. And the investigation officer called me, your lordship, to join the investigation. But it was, your lordship, the offense more than 10 years, your lordship. So I apprehend.
Which offense?
It was, your lordship, 89 section, your lordship.
What is 89?
89 miscarriage, your lordship, without the consent of the victim, your lordship. The consent of the informant, your lordship, in this case, your lordship. And the Gauhati, your lordship, certified, your lordship, that there is no marriage, your lordship. There is no, and one allegation is more there, your lordship.
The offense would be graver if there is no marriage. Offense may be graver.
Lordship, I admit that fact, your lordship. Offense would be, but the fact, your lordship, now, your lordship, this is not the trial court where I can, lordship, establish the fact in my favor, your lordship. I have at this time, your lordship, the certificate issued by the Gram Pradhan, your lordship, to partially deny the allegation, your lordship. Partially deny the allegation, and even, your lordship, I have the whole villagers will witness this case, your lordship. And the whole villagers is ready, your lordship, to go before the investigation officer and to give their evidence, your lordship. Whole villagers are ready, your lordship. The whole villagers know the fact, your lordship, because there is no marriage, your lordship. One more allegation they leveled, your lordship. She leveled, your lordship. I got second marriage, your lordship. That is also there, your lordship. But the certificate is there, your lordship, from the Gaupura, your lordship, from my gram, your lordship. That is at page number.
Not a.
Lordship.
Evidence, it is a Hindu Marriage Act. Evidence is not from the Gaupura, lordship.
No, your lordship, I admit, your lordship. Here, your lordship, I can't even give the evidence, your lordship. I know that fact, your lordship.
Cannot
But
be taken into account.
but this is not the trial court, your lordship, where I
This
can
is, lordship,
I can establish my fact, your lordship, in my favor, your lordship. Now, at this point, your lordship, even, your lordship, on the ground of delay, your lordship, threaten of judgment the day of Honorable Supreme Court, your lordship, where the FIR has been quashed, your lordship. So at this stage, your lordship, after coming to page number 20, your lordship, the certificate, your lordship, I can thus I admitted, your lordship, with due respect, that this is not the stage, your lordship, where I deny all the allegation level against me, your lordship. But without Lordship, I have nothing to prove, to deny these things, Your Lordship. So 20 has, I have annexed, Your Lordship, with this petition, Your Lordship. Where, Your Lordship, it was clearly mentioned, Your Lordship, there is no marriage, Your Lordship.
Miss G. Bora, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Pankaj Das, impugning, apprehending his arrest in connection with Tinsukia PS case number 113/2026 under section 296/85/351 within bracket 3/82 within bracket 1/89 of BNS 2023, read with section 3/4 of the Dowry Prohibition Act 1961. The gist of accusation in this case is that on 12/5/2026, the victim woman had lodged an affair before the officer in charge of Tinsukia police station, inter alia, alleging that she was married to the present petitioner on 25/7/2012 as per Hindu rituals, and thereafter they started living together as husband and wife at Basudev Bari under Joklabandha police station in Nagaon district. It is alleged in the FIR that after few weeks of the marriage, the informant caught her husband red-handed in a compromising position with another woman, and after that matrimonial discord started between them. It is alleged in the affair that the petitioner started mentally and physically torturing the informant mentally and physically on a regular basis, and also demanded dowry from her. It was also alleged that when the informant got pregnant, she was forced to abort her pregnancy by the present petitioner. It is also alleged in the affair that in the month of February 2021, the informant was driven out of her matrimonial home by the petitioner. Learned counsel for the next paragraph. Ms. G. Bora, the learned counsel for the petitioner, has submitted that the allegations leveled in the affair against the petitioner are exaggerated. She submits that there was a love affair between the petitioner and the informant. However, no formal marriage was there between them. And to that effect, the petitioner has furnished a certificate from local Gauhati. She further submits that the allegations leveled in the affair dates back from the year 2012. However, no reason has been stated in the affair for the delay in filing the FIR. She submits that the petitioner is ready to cooperate in the investigation. However, as one of the offense involved alleged in this case, that is offense under section 89 of BNS, provides for punishment up to 10 years or more than
Extend to 10 years, Lordship.
up to 10 years. He apprehends that he may be arrested at any time. On the other hand, learned additional public prosecutor Mr. K.K. Das vehemently opposed the grant of any interim relief at this stage, considering the nature of allegations leveled against the petitioner in the FIR. He submits that the case diary may be called for. Let the case diary be called for. Let this case be listed for case diary on 7th of August. 7th of August. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as well as materials available on record, the petitioner is directed to appear before the investigating officer of Tinsukia PS case number 113/2026 within 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest, comma, in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number one, why this matter came before this court?
Because it was withdrawn from this honorable court, earlier bail petition was the opposition.
Let this matter be listed on the 8th of
Much obliged, Lordship.
7th of for case then.
Much obliged, Lordship.
Orders, item 15.
May I please lordships. In this case, my lord, already matter has been fixed on my lord as per earlier order, my lord. Fixed on 24/7, my lord. For hearing, my lord.
For hearing,
For hearing, my lord, already. I've just, my lord, from e-courts, my lord, I found. To 24/7 of this class, I will be the exam.
it is ready for hearing. Heard Mr. S. Ahmed, learned counsel for the appellant, also heard Mr. A.J. Swakya, learned counsel for the respondent. It appears from record that by order dated 18/6/2026, this matter was directed to be listed on 24/7/2026 for hearing. Stop. It appears that the matter has been wrongly listed today in the orders column. Let this matter be listed for hearing on 24/7/2026.
Obliged, my lord. Much obliged.
The matter may be taken up after some time.
Please, this is your lordship. Lordship, respondent number 2 and 3 are not served, but this case is on quantum, so the notice to them may be waived and the case can be fixed for hearing. Lordship, the LCR is also received because quantum is between.
Heard Miss Adi Majumdar.
As per order 6/10/2024, they have to supply the copy of the appeal letter.
Okay.
Oh.
Yes,
That's why order is 6 and 22.
Okay.
Respondent 1 and 4.
Miss Adi Majumdar, learned counsel for the appellant. Also Miss Mr. N.J. Gogoi, learned counsel for the respondent number
1 and 4.
1 and 4. Learned counsel for this appellant submits that the notice to respondent number 2 and 3 could not be served by the CMOD. Stop. However, she further submits that since the appellant is mainly aggrieved in this appeal with the quantum of compensation awarded to the claimant, hence the presence of respondent number 2 and 3 may not be necessary for adjudication of this appeal. She therefore submits that notice to the aforesaid above mentioned respondents may be waived and this matter may be fixed for hearing. The prayer is not opposed to by learned counsel for respondent number 1 and 4. 1 and 4. The prayer is accordingly allowed. Let this matter be listed for hearing on 8th of October.
Hello.
I have instruction to withdraw this matter, Lordship.
Third, Mr. P. Sharma, learned counsel for the petitioner. Also, Mr. P. P. Datta, learned counsel for respondent number 1. Learned counsel for the petitioner has submitted that he has been instructed by the petitioner to withdraw this contempt case. Accordingly, prays for allowing to do so. The prayer is allowed. This contempt case is accordingly dismissed from withdrawal.
Highly up. Item number 18.
May I please, sir?
What is your name?
S. Sema, sir.
Heard Miss S. Sema, learned counsel for the applicants. On perusal of the office note dated 13/7/2026, it appears that notice to respondent number 2 and 4 have returned without service with endorsement indicating insufficient address. What will you do to find out the proper address?
Sir, how can we take out the address?
Then you go for newspaper publication. The learned counsel for the applicant submits that the applicant does not have you take proper instruction before going. And does not have the proper address of respondent number 2 and 4. However, she prays for some time to take instruction in this regard. The prayer is allowed. Let this matter be listed. Putul short day, August first week. 6th of August.
I yield.
Item 20 and 21.
Get a fixed quality. My lord, case here has been received. Date may be fixed for hearing of the matter.
Copy has not been provided.
No, last time didn't it?
It is 22 later, you was there.
It was the EMI bill from
Heard Ms. T. Som, learned counsel for the appellant. Also heard Mr. J. Kolita, learned counsel for the respondent. I am not,
it. One.
I am not mentioning it.
May I please, Lord, in this item number 18, I am appearing for respondent number 1.
And item number 18, keyhole.
Taking the earliest lordship in item 21, there's an interim order operating that may be continued.
In item number 18, reflect the name of Miss D. D. Burman, learned.
And for the
For the insurance company. Respondent number 1. And in item number 21, the interim order shall continue till next day.
So you kindly see the office note dated 11/3/2026, madam. Notices were issued, no response from the bank side, even there is a request made by the registry. The office note reflected. 11/3. This is a suo motu contempt taken up by the High Court, my lord.
Why, what was the matter?
Matter, my lord, this is contempt suo motu taken up because it was, there is some violation of the order that, my lord, contempt case was filed before the, my lord, ESI court, and probably under section 15(2) of the Contempt of Court Act, my lord, this court has taken suo motu contempt. Notice has already been issued, my lord. I have seen the office note of the registry, my lord. They have not even responded to the, my lord. So, my lord, let the reminder may be issued to the, my lord. The registry may be directed to issue reminder, my lord.
Otherwise, what will,
My lord,
otherwise, what options are open?
no option, my lord. Because bank official has to furnish that where is that person now. That information was sought by the registry of dishonorable court, but no response from the, my lord, branch manager Shilpukuri, my lord.
You are appearing for?
No, that is suo motu I am appearing on behalf of the High Court.
Okay. Heard Mr. T.J. Mohanto, learned senior counsel, assisted by
P. Sharma.
Ms. P. Sharma, learned standing counsel. You are standing counsel,
Senior standing.
senior standing counsel of Gauhati High Court. It appears that by which order suo motu contempt was?
Kindly see the, my lord, office, the page 104, my lord. Page 104 and 105. The note, see the sixth note, my lord, that is 26/11/2025. last part of the, my lord, page 105, 105.
It appears that in the instant suo motu contempt case was registered as per the direction of Honorable the Chief Justice on 28/11/2025. Thereafter, who is the respondent?
That's page 1, my lord. Krishna Deka, branch manager, Punjab National Bank, Silpukuri Mas, Gopinath Bordloi Road, Gauhati 1. Page 1, my lord.
Thereafter, notices were issued to she is the contemner,
My lord.
to the contemner / respondent, Krishna Deka, who is the branch manager of Punjab National Bank, Silpukri branch. On 19/12/2025. The said notice returned. Said notice were not served on the contemner and same returned with a report indicating that no such person by the name of Krishna Deka is found at Punjab National Bank, Silpukri branch. Accordingly, on 6/2/2026, a direction was issued by this court to implead to take steps to take fresh steps for issuance of notice on the sole contemner or to implead the new incumbent. Why new? What was the contempt?
Contempt, my lord, some order of the, my lord, ESI court was, my lord. There's a order that they do not to disburse the money, but in spite of that, it is, my lord, disburse the money. So that's why, my lord.
Oh, contempt of ESI court's order.
Yes.
Therefore, suo motu.
Then it was filed before the ESI court and sent it to the High Court, and accordingly, High Court raised it.
ESI court has sent a reference.
That is 15-2. And contempt of
Okay.
court 15-2.
क्या लिखा अभिषेक क्लास or to implead the new incumbent. However, on perusal of office note dated 11/3/2026, it appears that the registry had requested the branch manager of Punjab National Bank, Silpukri branch, by its letter dated 25/2/2026 to furnish the details of the person who is holding the post of branch manager of Silpukri branch during the period of August 2026 August 2020 August 2025. However, no information was received from the said bank. Thereafter, registry issued another letter on 7/3/2026 requesting the branch manager to appear before Registrar Judicial on 10/3/2026 with requisite detail. However, the branch manager, however, no response was received against the said letter. Now, what do you suggest?
My lord, again one
reminder.
one reminder. There
Stop.
should be there.
Let a reminder be issued to the branch manager of Silpukri branch of Punjab National Bank to furnish the details sought for by the registry in pursuant to this order of this court once again. Let this matter be listed again on first week of August,
Definitely.
7th of August. Registry to take steps accordingly.
Definitely.
May I please, your lordship?
Yes.
This is an appeal against order of dismissal of temporary injunction. TCR has been received, my lord. Date may be fixed for final hearing.
The service is complete.
Service is complete, my lord.
Heard Mr. D. Majumdar, learned counsel for the appellants. It appears that service of notice on both the respondents is complete, and the scanned copy of the trial court records have also been received. Let this matter be listed for final hearing on August or 6th of August.
Much obliged. My lord, there is an IA, my lord. That may also be considered on the next day. IA is for a temporary injunction, my lord.
No, we'll dispose of it finally.
Much obliged.
Let the IA be listed along with the
Let it be listed.
main appeal on the next date fix.
Much obliged.
May I please now? On the last occasion, respondent side took some time to file the reply. The reply to file. I
think what?
I stay application.
Condemnation.
No. Condone to hold. In the I 2312, if your lordship uses the last order for the I.
What for this IA is?
For the stay of the execution of the order and judgment dated.
What was the order?
So the divorce was granted
And
against. I came in appeal and I filed in application for stay of the order. And an interim order was granted. Then the respondent side took some time, showed some time for filing the reply to my IA.
what stay?
Stay of the execution of the divorce.
What execution?
Execution as in, my lord, if the
Wait,
stay is not allowed, my
is
lord,
there
you might
any
get married.
execution proceeding in divorce cases?
My lord.
Is there any execution proceeding in divorce cases?
Execution in the sense, my lord,
if it's not state, he might get married, my lord.
So you
So that my
3 and 4 have also filed their wakalatnama in this case. However, what happened to respondent number 2? However, service report in respect of respondent number 2 is awaited.
Not counted, Lordship. Lordship, when we issued a fresh step, Lordship.
No. Oh, yes. Yes. The appellant is directed to take fresh steps by by speed post as well as by usual mode upon respondent number 2 within 7 days from the date of this order, returnable on 17th of August.
Interim may be extended, Lordship. Interim order.
When interim was granted in I.
RFA 51 of 20.
In IA also same orders, same duplication of last line, the stay granted earlier, interim stay granted earlier shall continue till next day. Released on 17th of August.
3063. Copy of that has not been served to us.
During the course of the day, we will.
Yes, you serve it during the course of the day. She will serve you. I am not reflecting it in the order sheet.
Obliged, Lordship.
Item 26.
In this case, my lord, I could not take a step. At that relevant point of time, some different order was uploaded, my lord. In the record, it is correctly perused, my lord. The order is correctly placed. But in the online system, some different order was uploaded, due to which I could not take a step.
Amita,
Later on,
verify karna.
later on today, I have verified in the online. This is corrected. This was earlier order.
Okay.
Now it is corrected.
Check karna.
I am ready to take it.
Heard Mr. A. Rahman,
Right.
learned counsel for the appellant who submits that he could not take steps for issuance of notice upon the respondents, as on earlier occasion a different order was uploaded in the website of High Court instead of order dated 15/10/2025, which was later on rectified. He therefore prays for some more time to take steps for issuance of notice on the respondent. How many respondents are there?
4 numbers.
Respondents.
Right.
The prayer is allowed. The appellant shall take steps for issuance of notice upon all the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 19th of August.
Also present.
Item 28.
Made with your lordship, as per office note dated 9/7/26, lordship, TCR received, and according to process server, notice to R7 was received by wife. For R6 could not be traced out and return answer flag Y, and AD card has not yet been received back, lordship. So in fact, 7 is served. For 6, I think we'll have to await service report.
6,
Or
who is
take
6?
fresh.
You take fresh.
Owner
You take fresh steps.
fresh.
Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. D. Mondal, learned counsel for respondent number 125. On perusal of the office note dated 9/7/2026, it appears that notice issued to respondent number 7 was received by his wife. Accordingly, the said notice is held to be duly served on respondent number 7. However, notice issued to respondent number 6 would not be served. The appellant is directed to take fresh steps for issuance of notice upon respondent number 6 by speed post as well as by usual mode.
Usual today he could not serve.
Oh, sorry, by speed post within 7 days from the date of this order, returnable on 17th of August.
May I please, your lordship? Stay application is still pending. And there was stay application.
No
I'll
stay,
get it.
no stay flight.
They are not
Eight.
pressing. They are not pressing.
Yes.
Stay, they should be bothered about stay. Suppose they are not pressing for stay. You go for execution before. You're
He had filed one application, he is supposed to file amendment, that is the order in his
Your lordship,
application.
on the last occasion,
But he has not filed any amended petition.
on the last
It-
occasion, I have read that there is some amendment is required to be made. But of
who
course,
filed this IA?
this IA has been filed by
1576 by-
respondent.
1576
Yes, your lordship.
by you.
No.
By me, your lordship.
For-
By the claimant.
That he wants to amend the year, but he has not.
For
yet
what?
filed.
Your lordship, here my prayer is that the insurance company, after filing the appeal, there was a 1 year, 4 month, 4 days delay in rectifying the mistake before the registry. So my prayer was that at least some cost may be imposed.
That is already
Whether
gone,
that
lordship
is-
already admitted, and they want a review, so it has to be listed before the same bench, which, yeah. And moreover, lordship, what cost?
While admitting the appeal, cost should have been imposed. That is
Yes,
your prayer.
Yes.
But this prayer, the appeal has already been
No, your
admitted.
lordship, on the appeal has been admitted ex parte. Appeal has been admitted ex parte since it was filed within time. So only after admission notice goes to the claimants.
Everyday defects are there, lordship. Everyday filing defects are there. No one files a petition for exemplary cost.
Your
His
lordship-
prayer is exemplary cost, and last order, lordship will see, he wanted to amend this petition.
Your
And now
lordship-
he is presenting the petition itself without amending.
your
That
lordship,
order is there.
Had it been 1 month, 2 month, 3 month delays, I would have not objected. 1 year, 4 months, 4 days delay.
Okay, you amend. What was the prayer made in this interlocutory application?
Actually, your lordship, an application for review, modification, alteration of the order. Now, if this.
Review
this
can be done by the
the court which passes the order.
order.
So I want to amend this part only.
Which part?
This an application under section 1, I will amend it so that any court can pass an order.
Then you amend, you have the leave was granted on
Yes,
last
it was
day.
granted, but your lordship, this claimant number 1 is.
You have not amended it.
No.
Now
I
what
have
do
prepared
you,
the amendment petition,
what do you want?
1 week time, your lordship.
Okay. And I heard Mr. D. Mondol, learned counsel for the applicant, also Miss R. Not heard Mr. D. Mondol, learned counsel for the applicant, who prays for some time for filing an amended interlocutory application. The prayer is allowed. Let this matter be listed again. 17th of August.
Hello.
17th, that week I will be,
Yeah.
that 28 of the but that next week.
28.
Because
August.
17 to 21, I'll be.
28th August.
Hello.
Oblige you.
Who is for the petitioner?
The last occasion also none appeared, my lord. There was an order, my lord, of 2611.
You are appearing for
For the respondent, my lord. Sole respondent, alleged contempt.
What should we do?
Actually, we have filed our affidavit in opposition. My lord, there are disputed question on facts, my lord, regarding the permission of contempt.
Okay, we'll list it again on a different date. None has appeared for the petitioner on call. Mr. G. Rahul, learned counsel for the contemner, is present. He submits that the contemner has filed an affidavit on opposition in this case, which is on record. Since the petitioner is found absent on call, let this matter be listed again on 7th of August,
But can it be there after 15th, my lord?
after 15th. 19th August.
Pleasure.
May please, your lordship. My lord, this matter is analogous to item number 35, lordship, 35 and 36, lordship. 35 and 36, yeah, lordship, services complete except 5. Whereas, lordship, in analogous matters, 35, the response number 5 appeared, lordship.
35 Martin.
35 and 36.
Who is appearing for?
Your Honor, I'm item number 30, I'm appearing respondent number 1 and 2.
And are you also appearing in 35?
Yes, Your Honor. But Your Lordship, I did not receive any notice, Your Honor. Yeah, item number, oh no, this mistake, Your Honor.
Okay, we'll
This is-
take one by one.
It's an application for condonation of delay, Lordship. Item number 30, Lordship, there is a delay of 48 days in preferring the appeal,
Who is 5?
Lordship.
Who is respondent number 5?
Respondent number 5 is the owner of the Lordship, Omid Kalita, appeared in the another cases, Lordship, in IA number 714 of 25. 5 is the owner, driver of the vehicle, Lordship. Omid Kalita. In the last occasion, it appeared in the analogous cases.
Who is appearing on?
Omid Kalita.
Who is the counsel who is appearing?
Council is. The question come to. Yes. I don't know. Sohan, Mr. Sohan, M. Borua, R. Dev. Yes, T. Kolita. H. Das is also appearing, Lordship, for the claimant.
No, who is appearing for driver of the?
In case number, Lordship, you'll find in item number 35, Lordship, in IA.
No, we'll take one by one.
Yes, Lordship. Advocate name.
In item number 31, heard Miss M. Chaudhary, learned counsel for the applicant. Also heard Miss, what is her name? C. Burman, appearing for respondent number 1 and 2. On perusal of, you have not taken steps.
Regarding respondent number 5, Lordship.
Yes, you have to take steps.
Yes, respondent number 5, Lordship, since they have appeared, Lordship, in the same, on the same day he appeared. Therefore, I thought that, Lordship, he will be appearing in this case also.
But there is a direction for taking steps.
Caller, yes, I will take. Lordship.
On perusal of the office note dated 8/7/2026, it appears that the applicant has not taken steps for issuance of notice upon respondent number 5 by speed post as was directed by this court. The applicant shall take steps.
Fresh steps, Lordship.
Take fresh steps for issuance of notice on respondent number 5 by speed post within 7 days from the date of this order, returnable on 17th of August. Then item number 35.
$35 and $36, sir. Wait, it came with.
35 and
This is also, Lordship, delay petition.
Heard Miss M. Chaudhary, learned counsel for the
Proceed, item 35. I will file the ISC 3480/25. Your Honor, in this case, I am filing the IS for the 50% amount.
No, the appeal is not yet admitted.
Delay is not yet condoned.
Delay is not yet condoned. You can object to. The delay may not be condoned. Then you may go for 100% before the. Have you filed any interlocutory application?
3490.
That is premature.
3480. 3480. Oblique 25.
3480. This is premature application. The appeal is not yet registered, is yet to be registered.
The delay of 38 days, Lordship. Services. There's the office not, Lordship. 13/5/26, Lordship.
And what is 36?
36 is same, Lordship. There is a delay of, Lordship, 66 days. Same party, Lordship, all are appeared.
And 35?
35 and 36. With 36, it came with. Services complete, Lordship.
What is your IA number?
IA number is, Lordship.
714.
714, yes, 714/25 in item number 35, Lordship.
Item number 35 or 714 of the order. लिखेगा. Heard Miss M. Chaudhary, learned counsel for the.
Yes.
Are you opposing delay condonation? Heard Miss M. Chaudhary, learned counsel for the applicant. You are claimant.
Yes. For the claimant.
Also heard Miss. What is your name? C. Burman, appearing for respondent number 1 / claimant.
Yes.
But you have to issue notice to
Respond number 5.
respondent number 4.
Respond number 4. Same person, Lordship. Amit Kalita.
Yes.
He appeared on that day, Lordship. He appeared, Lordship,
Where?
in IA 714 on 13/5/26.
Respondent number 2.
Or 5, Lordship. Respond number 5.
Who is for National Insurance Company?
National T. Kalita. He appeared on last occasion.
No, there is no indication in the order sheet.
Since it said analogous may be passed in one English.
No separate order Okay, okay.
Where will be the Only it is mentioned that lordship in the office note,
Okay.
white 4/11/25 shows that notices were issued, duly served. Specific mention is not there, lordship. It is not specifically mentioned, lordship. Duly
It
served.
appears that on last occasion, that is on 13/5/2026, Mr. T. Kalita appeared for respondent number 2 and prayed for some time for filing wakalatnama. However, there is no indication in the office note as to whether respondent number 2 whether Mr. T. Kalita has filed any wakalatnama in this case on the office to verify the same and list this matter again on 17th of August.
Yeah.
36.
36, lordship. It's a petition for condonation of delay, lordship, 66 days delay. Analogous matter, lordship. These three are, all the three cases are analogous, lordship. Here also, lordship.
Same
notices-
party.
Yes, lordship. Same
36.
parties.
Mita, earlier order made 36. Same order. Common order.
Yes, lordship, common order.
17.
And it may come with, along with 30, lordship.
Yes.
30, 35 and 36 may
Common
come
order.
together, lordship.
List this matter
Yes.
along with IA 716. IA number 716. IA number
714
714
and IA number
and IA number
4007.
4007 may be listed together on the next date fixed.
Yes, lordship. On 17/8, lordship.
17A.
Must oblige.
Item 31.
Lordship, service body already responded are completed, Lordship. And there is an IA for continuing the delay for a period of 178 days, Lordship. Completed, yeah, completed. And Lordship, this matter was connected with the item number 33, Lordship.
30?
33, Lordship. There is same cause of action, Lordship.
In 33 also, is there any delay?
Lordship, there is a delay.
So we'll take one by one.
Lordship,
Here service is complete.
complete, Lordship. Both the cases, the service.
Lordship, when the owner appeared, lordship, this is Amit Kalita. I am also appearing for Oriental, lordship, with arrest number 6. The lordship owner appeared, therefore lordship service is done. It is completion. Oriental. These are all analogous, lordship.
No, will you file written objection in this case? You are conceding. So 31 at Likhibo. Heard Mr.
Ekakoti.
A. Kakoti appearing for the applicant. Also heard Miss C. Burman appearing for respondent number 2 and 3, as well as Miss M. Chaudhary appearing for respondent number 6. This application under Section 5 of the Limitation Act 1963 has been preferred by the National Insurance Company Limited, praying for condoning the delay of 178 days in filing the connected MAC appeal, whereby the judgment and award dated 5/7/2024 passed in MSC case number 88/2026 by the Motor Accident Claims Tribunal, Bongaigaon, has been impugned. The learned counsel for the applicant has submitted that the reason for delay has been mentioned in which para?
Para 3 to 10 Lordship.
Paragraph number 3 to 10 of the instant interlocutory application. You are opposing? Learned counsel for the respondents have submitted that they do not have any objection if the delay is condoned in this case. I have gone through the reasons stated in the instant interlocutory application by the applicant for approaching this court belatedly in filing the connected appeal. The said reasons may be regarded as sufficient cause which prevented the applicant from filing the connected appeal within the prescribed period of limitation. As such, the delay of 178 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. The registry shall register the connected MAC appeal and list the same for admission on 17/8/2026. 30.
33 Lordship.
Yes, 33.
There is a delay of 162 days Lordship.
Same parties.
Same parties Lordship. And the same accident Lordship.
I have not received the copy of the petition.
You
I
furnish
provided
the,
the copy.
you furnish the copies. Heard Mr. A. Kakoti, learned counsel for the applicant. Also heard Ms. C. Burman, learned counsel for respondent number.
Okay.
Who is for Golapi Devi, respondent number 1?
And the case is tried. They, let's say, their daughter Sampurna and Bharadwaj, they are minor. There is a guardian.
She is the legal guardian
Legal
Lordship,
guardian.
appointed by the district court
PMA.
Srirang Lordship.
Okay. So she otherwise do not have any interest in the case.
Lordship.
Respondent C. Burman, learned counsel for respondent number 2 and 3. Also heard Ms. M. Chaudhary, learned counsel for respondent number 6. On perusal of the office note dated 3/11/2025, it appears that for respondent number 4 and 5, Wakalatnama has been filed by the engaged counsel. It is submitted by learned counsel for the respondent number 2 and 3 that during the inquiry before the tribunal, the respondent number 2 and 3 were minor, and therefore present respondent number 1 was appointed as guardian ad litem by the tribunal. She submits that for this appeal, the presence of respondent number 1 may not be necessary, as respondent number 2 and 3 have now attained majority. As such, the notice to respondent number 1 is waived in this case. Stop. The service of notice on all the respondents is complete. However, learned counsel for respondent number 6 submits that she has not received the copy of interlocutory application. Stop. As such, learned counsel for the applicant is directed to furnish a copy of the instant interlocutory application to the learned counsel for respondent number 6 within 7 days from the date of this order. Let this matter be listed on 17/8. Yes. What is this?
I'm appearing on behalf of respondent number 1.
Make appeal to the officer. What is to be done?
Appeal is not yet admitted, but I have got no objection for admission of the appeal, subject to the prayer that they must deposit at 50% of the amount.
No, but no one has appeared.
Yes, that's true.
On last occasion also, nobody.
Yes, last occasion also they did not appear.
We'll fix a date.
Let it be dismissed.
One chance. None has appeared for the appellant on call. Mr. S.C. Bishwas, learned counsel for the
Respondent number 1.
respondent number 1 is present. You are also
No.
same. Let this matter be listed again on 3rd August. Before that, ek line likhibo. It appears from record that on last date also, that is on 22/10/2025, none appeared for the appellant when the matter was called. Let this matter be listed on 3rd of August. Yes, Mr. Jain, you are appearing for respondent number? Mr. R.K. Jain also appeared for respondent number
2.
Respondent number 2. 3rd of August next day.
Similar matter. Same accident. This honorable court has passed the order demanding that the matter to the trial court, the trial tribunal, to take the evidence in press.
Okay.
And
But
my learned junior to take the photocopy of that.
okay. On next date, if the appellant appears,
Yes.
we may pass the same order. Otherwise, we will dismiss the appeal.
Then let this submission come from the end of this appellant. They are absent on the second occasion.
Yes.
They are not interested.
Let us see what happens on next date. 3rd of
It will
August.
further delay the matter. They are
3rd of August.
3rd of August.
3rd of August.
May it please the Lord. My lord, this in this item, my lord, 75-day delay in filing the RFA, my lord. So notice we took steps on respondent 1, 2, 3, and 4, my lord. However, now respondent number 1, my learned friend has appeared. And respondent number 3, my learned friend has also appeared, my lord. And in respect of respondent 4, my lord, I pray that I will take fresh steps, reserve steps, my lord. And one thing more, my lord, I beg to mention, that is respondent number 2, my lord. The respondent number one, Mr. Prasenjit Delashkar, he is the proprietor of grounds filing station, Ganesh filling station. So virtually he is the one and same person, my lord. This respondent number one is covering the two also. So I may be exempted for taking steps in respect
You
of.
are appearing for, who is appearing for
I
what?
appear for respondent number one.
You are
so far-
appearing also for two.
My lord, respondent number two, there is a technical difficulty. Respondent number two as on date does not exist. It is a non-operational entity. It was closed down due to cancellation of license of respondent number one.
Okay.
Now, that's the reason why I have not been able to file any wakalatnama on behalf of respondent number two. Although the respondent number one was the erstwhile proprietor of respondent number two.
May not be existing, but since my learned friend is appearing for one, my lord, it amounts that even against the non-existence one,
Will reflect his submission. And against other respondents,
in respect of respondent number, my lord, 5 to 16, I pray before lawsuit for striking of the name, these names, because my lord, they did not contest in the courts below, they are not cooperating at all. So their names will be struck.
no, they did not contest with what order you are impugning.
My lord.
This
The
is a
but
delay
the fight is
continuation.
in between the plaintiff, present appellant and respondent number 1, 2, 3, and 4, my lord.
This is a delay condonation application.
Delay, this is a delay condition of 75 days here, my lord. So this delay may kindly be condoned if your lawsuits, and I will take fresh steps in respect of
In the main appeal, which order you are impugning?
in the main the judgment of the court, honorable courts, my lord.
Before the trial court, whether these respondents filed.
These respondents did not contest, they did not appear.
Anything you want to say?
I'm appearing for three.
The delay be condoned and let the appeal be
I
registered.
think technically respondent number four has to
So,
appear and then
the bank has not yet appeared.
let the steps for four be completed and
Four
then
has to appear.
that then thereafter the striking of and the delay condemnation can order
Yes,
can be passed.
yes.
Okay, I think Lordship, no effective order can be passed. Only the steps for respondent number four.
Heard Mr. M. H. Rajbar Bhuya, learned counsel for the applicant. Also heard Mr. D. Chakravarti. D or B? D. Chakravarti, learned counsel for respondent number one. Also heard Mr. R. J. Das, appearing for respondent number
3, my lord.
3. Government is also there, no? Respondent number?
Oh, 10, 9, 10.
For respondent number 4, I will take steps, my lord.
7, 8, 9.
8, 9, 10. 9, 8.
Respondent number Mr. T. R. Gogoi, learned government counsel, appear for respondent number 7, 8, 9, and 10. Learned counsel for the applicant has submitted that the respondent number 1 was the proprietor of respondent number 2, and therefore he may be therefore the petitioner may be exempted from taking steps for issuance of notice on respondent number 2. On the other hand, Mr. B. Chakravarti, learned counsel for the respondent number 1, submits that the respondent number 2 is a non-existing entity, as
The license of respondent number 1 was already cancelled.
license of respondent number 1 in respect of respondent number 2 entity was cancelled. In view of submissions of learned counsel for the applicant and Learned counsel for respondent number 2, respondent number 1. The notice to respondent number 2 is hereby waived. The applicant is directed to take fresh steps for issuance of notice to respondent number 4 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 21st August. As regards notice to respondent number 5, 6, 11, 12, 13, 14, 15, and 16 is concerned, are concerned. Learned counsel for the applicant submits that the said respondent did not contest the suit before the trial court also, and therefore notice to them may be waived. The prayer is accordingly allowed. Let this matter be listed again. 21 August.
I will take steps on respondent for my
Four.
by registered post.
By speed post.
As well as usual, I think. As well as usual, I think. It has ordered usual also. Speed post as well as.
Speed post and usual mode.
Obliged.
Obliged.
Written number.
My lord. Item 37, 42, and 43. These are all connected. There is a delay petition.
How it can be connected now? There is delay in every case. So every case has to be dealt with separately. Only after delay is condoned, they may be connected. Now there cannot be any connection.
My lord, so far as the delay is concerned, here, the
30.
delay is of 27 days in item number 37,
Yes.
27 days.
You are opposing.
Yes, I filed my objections in all three.
You have filed.
Yes.
Okay. What is your submission?
My submission is that, my lord, that the delay here is beyond the control and capacity of the petition, applicant. Because I was entrusted to this case and I was suffering. And I have annexed my medical documents.
Who was suffering?
I was suffering.
Counsel.
Yes, my lord. And the time was taken for obtaining the certified copy also, the time was taken. And as I was suffering until date I am undergoing treatment. But in spite of that, whenever I got a bit comfortable, I prepared this thing and I filed it. My lord, there is a delay of.
Now, whether counsel's inability difficult.
Yes, there is. For the, if it is taken into consideration that there is any lapses on the part of the counsel, then the petitioner should not be allowed to suffer.
And then counsel should compensate it. If counsel is taking benefit of his difficulties, he should also compensate. Whether he should compensate or not, that is my query. Otherwise, every counsel will start taking these pleas that I am ill.
My lord, here, this thing, I have annexed my medical documents.
No.
And
whether the counsel is aware about the period of limitation.
yes,
Law of limitation is known to the counsel.
yes.
So if he is of the view that limitation period will expire due to he should give proper advice to the client instead of later on taking the plea.
My lord, that I have annexed my medical documents And there, that I got a fall in the chamber itself.
No, when counsel is submitting that he was ill, that I'm not doubt, I don't have a doubt on your submission. My question is on a different line. That when counsel knows that he is ill and the period of limitation is going to expire, can he take this plea that later on I will take my own ground?
My lord, so far as they have made the written this thing objection, where if lordship kindly peruse, that they have said that they have said that the writ appeal should not be entertained. Their prayer, if lordship kindly peruse this.
Okay, so your ground is that they engaged a counsel and the counsel was ill and therefore the appeal could not be preferred within the prescribed period of. What is your objection?
Chip, from what has fallen from your lordship regarding the ground on counsel's difficulty, lordship, perhaps that was discussed by the Supreme Court in Borsay Brothers, which is the hard limitation under the Arbitration Act. In that case, lordship, from what I recall, that aspect was dealt with. So if lordship so desires, I can place the judgment on a subsequent date. Otherwise, as far as these facts are concerned, we have taken two grounds, lordship. Firstly, that sufficient cause is not built out from the averments in the condonation application. Secondly, lordship, I don't want to urge it, but the fact remains that the medical documents that have been placed on record, some of those predate the decree. The three documents, two of them are actually prior to the decree, lordship. So those are essentially the aspects we have forged, lordship.
Yes, Mr. Nath, you have anything?
Considering the days, 27 days, I'm not filing any objection.
What was held by the apex court in the judgment which you are referring to?
Lordship, in Borsay Brothers, ultimately the question was on the hard limitation of the Arbitration Act. That was held to be that it could not be condoned except with a certain limitation. But in that facts of the case, there was also the ground of counsel's difficulty. So that was, lordship, I think, not treated favorably. That I will have to check up, lordship.
My lord, just they have annexed the judgment, and that judgment says that there is a delay of 5 years and half months, 5 years and 5.5 years. They have annexed, and if lordship kindly peruse the page number 85, there E, the subclause E itself says that the appellants, landowners preferring an appeal before the High Court after the delay of 5.5 years for enhancement of compensation. So this judgment has got no relevancy. Here the delay is of just 27 days.
Okay, heard Mr. D. Nandi, learned counsel for the applicant. Also heard Mr. D. Nath, learned senior government counsel, appearing for respondent number 1 and 3. 1, 3, and 6. Stop. Also heard Mr. What is your name? Atreya. T-A. Atreya. Learned counsel appearing for respondent number 2, 4, and 5. This interlocutory application under Section 5 of the Limitation Act 1963 has been filed by the applicants praying for condoning the delay of 27 days in filing the connected regular first appeal, wherein the judgment and decree dated 23/5/2025 passed in title suit number 23/2018 has been impugned. Learned counsel, Mr. D. Nandi, the learned counsel for the applicant, submits that he was engaged by the applicant to file the instant appeal within the period of limitation. But however, as he himself, within bracket the counsel, was suffering from ailments, he could not prefer the appeal within the prescribed period of limitation. Stop. In support of his submission, he has furnished medical documents indicating his ailment therein. Learned counsel for the applicant submits that the delay in preferring the connected appeal was entirely due to his lapse, as he was ill during the said period. Oh, stop. And as such, the applicant may not be made to suffer for lapse which was not theirs, and hence he prays for condoning the delay of 27 days. Stop. Mr. D. Nath, learned senior government counsel, submits that considering the grounds shown by the considering the grounds shown by the applicant in the instant interlocutory application, as well as the short period of delay of 27 days, he does not have any objection if the delay is condoned. On the other hand, learned counsel for respondent number 2, 4, and 5, Mr. Atreya, has objected to condonation of delay of 27 days on the ground that some of the documents which are annexed along with the instant interlocutory application pertaining to the ailment of the engaged counsel relates to ailment prior to the date of even decree passed in the aforesaid case. He further submits that the applicants have failed to show sufficient cause within the meaning of Section 5 of the Limitation Act, justifying condonation of delay in this case, and as such he prays for dismissal of this interlocutory application. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Though it is a settled proposition of law that while considering an application for condonation of delay, the courts should take a justice-oriented approach and take liberal view of matter wherever it is warranted. However, warranted stop. Do kati dibo. Do kati. Stop. In the instant case, it appears that the delay which has been caused in filing the connected appeal is entirely due to the reasons connected with the engaged counsel of the applicants, and the applicants were not at lapse for the said delay. They may not be, under such circumstances, they may not be made to suffer due to delay in filing of the connected appeal beyond period of limitation. As such, moreover, considering that the fact that the delay is only of a short period of 27 days, this court is taking a liberal view of the matter and condoning the delay of 27 days in filing the connected appeal. This interlocutory application is accordingly allowed. The registry is directed to register the connected regular first appeal and list the same for admission after 2 weeks on a date limit. Admission at the date the August on 5th of August.
5th of August.
Item 48.
May please your lordship. That's why at the last occasion, Honorable Court directed us to take steps for paper publication. We have informed the company, and now 1 week time will be granted to find out whether the company had taken steps or not.
Heard Miss what?
P. Huzuri.
B.
P. Huzuri.
P. Hujuri, learned counsel for this. This is an learned counsel for the appellant who prays for some more time to take instruction. No, you don't know whether steps have been taken or not.
Inform the company.
The steps have been taken, my lord. We have furnished the process to the company. Whether they have published it or not, my lord, we are not sure.
Okay. Who seeks some more time to take instructions, to take necessary instructions, and let this court know as to whether, in pursuant to the directions of this court, the notices were published in newspaper or not. The prayer is allowed. Let this matter be listed again on
2 weeks, lordship.
21st August.
Public.
Item 49.
May I please, lordship? Also, kindly peruse office note dated 15/6/2026, lordship. The service upon respondent 1, 2, 3, 5, and 6 were served duly, lordship. Also, it is also reflected that respondent 4 has expired, lordship. Acquired information, lordship, was unmarried.
When she was expired, when respondent number 4 expired,
Expired on lordship 41/3/2026, lordship.
on
21/3/2026. His mother is already party, lordship, as respondent number 3.
heard Mr. What is her name?
M. Borrow for R. Ali.
M. Boro appearing for Mr. R. and counsel for the appellant. Also heard Miss
Are they lordship?
Are they learned counsel appearing for?
Respondent number 1, 2, 3, 5 and 6.
Respondent number 1, 2, 3, 5, and 6. Learned counsel for the appellant submits that respondent number 4 has expired on 21/3/2026, and as respondent number 4 was unmarried lady.
Not lady.
Unmarried. Respondent number 4 is Mosam Gogoi,
Yes, Lord. Son of Minal
was an unmarried person, and his mother has already been impleaded in this appeal as respondent number
3, Lordship.
3. There may not be any necessity of substituting legal heirs of respondent number 4. Stop. It appears that the more than 90 days have lapsed since the date of death of respondent number 4. Hence, by operation of law, this appeal is abated against respondent number 4. It also appears that the trial court records have already been received. As such, this matter is ready for hearing. Let this matter be listed for hearing on 8th of October.
In this case, as per the process server report, the process server attempted to serve the notice, Your Lordship, but the main gate was locked, so he was unable to give the notice. But actually, the title suit is already pending, and the respondents already appeared in the title suit in the subordinate court, Lordship. So actually, there I have been submitted trying to avoid the service, so the notice may be deemed to be served, Your Lordship.
How it can be deemed to be served?
Because Your Lordship may come to annexure number 4, Your Lordship, that is page number 43. That is the order in the miss case number 1097 of 24. In
Yes.
this case, the respondents have already appeared in terms. The next date is fixed for objection to be filed by them. So, and the same address is given in this in the title suit and the present contempt proceeding, Your Lordship.
Have you taken steps by speed post?
Yes, Your Lordship. That has been returned due to insufficient address, Your Lordship. But again, the address is same, Your Lordship, as in the
Gate was locked. He could have pasted it.
Yes, Your Lordship. As
on
per
conspiracy.
yes, order by Rule 17, you ought to have pasted in the outside, Lordship. And because they are already participating in the civil court, so there is no chance that the address is wrong, Your Lordship.
How many contemners are
Two
there?
contempt, Lordship. Same address. Sri Chiranjit Borua and Sri Monojit Borua, both are sons of late Madhav Chandra Borua, residing at Khanapara opposite ESA Hospital.
Heard Mr. What is your name?
J. Das, Your Lordship.
J. Das, learned counsel for the petitioner. On perusal of the office note dated 2/6/2026, it appears that notice issued to the contemners by speed post have returned without service with an endorsement with an inverted comma insufficient address, stop RTS, inverted comma close. Whereas notice issued by usual mode have returned with the report of the process servers, indicating therein that on the date when the process server went to serve the notice, the main gate was found locked. Stop. Let the notice be issued again by usual mode with a direction that to the process server that the notice may be served by serving the same on the respondent number 1 and 2 personally, and if they are not found, by substituted mode as indicated in Order 5, Rule 17
Rule 17.
of the Code of Civil Procedure. The petitioner shall take steps for issuance of notice within 7 days, returnable on 21st August.
Highly obliged, Your Lordship.
May I please, Your Lordship? Lordship, Office Note dated 12/5/26 shows that the service of notice upon respondents is complete.
Lordship, in this case, although my name has been reflected in the copy of the receipt, I am not instructed by the insurance company. So I have to take instruction. It may come after 10 days, Lordship.
Heard, Miss, what is your name?
As Patwari's
S. Patwari, learned counsel for the
claimant appellant.
This appeal has been disposed of.
Lordship, it was settled before the look at the Lordship. Here was a conditional, if the payment is not made within the 45 days, the
Interest will be charged.
insurance company has to pay the interest part, Lordship. So,
So
whether the amount was deposited within the time or not,
it was not deposited on time, sir.
So why this interlocutory application?
the interest
Sir,
per day, I filed the interest.
To
No,
deposit the interest at the rate of 7%.
that was the direction. Already the direction was there. If they fail to deposit, they have to deposit the interest. If they have not complied with that direction, you have to go for execution of that direction.
Execution.
What is to be done? No, you take instruction first. Patwari, learned counsel for the applicant. On the other hand, Mr. K.K. Bhatta, learned counsel, submits that though his name has been shown as engaged counsel for responding in this case, however, he has not yet been engaged in this case by the company, and he has to take instruction from the insurance company in this regard and seeks 10 days time for the same. The prayer is allowed. Let this matter be listed. 3rd of
Obliged.
August. Same delay.
Same was there here. In this case, it is for 28 days.
Heard Mr. D. Nandi, learned counsel for the applicant. Also heard Mr. A. Atreya, appearing for respondent number 2, 4, and 5, as well as Miss N. Burman, appearing on behalf of Mr. D. Nath, learned counsel for respondent number 1 and 3. This interlocutory application has been filed by the applicants praying for condoning the delay of 28 days in preferring the connected regular first appeal, wherein the decree, judgment and decree dated 23/5/2025 passed in title suit number 21 of 18 has been impugned. What was the earlier item number?
37.
37 or যেটা order আছে add করে দিব as it is. Same order. Disposal.
My lord, 43 also
Same.
in the same party,
43 also same.
same party.
Same order. Separate order.
There is delay of 29 days.
Delay to silo. Okay. Same order.
Deeply.
Yes.
May I please your lordship? Lordship on 16/6/2026, lordship, stay was taken, lordship, the usual process, lordship.
But by speed post also you were directed.
Yes, lordship.
You have to take steps.
You speak.
Heard Miss S.
R. Deb.
R. Deb, learned counsel for the applicants. Also heard Mr. K. K. Bhattacharya, appearing
8 to 12. 8, 9, 10, 11.
appearing for respondent number 8, 9, 10, 11, and 12. It appears from within bracket state respondents. Learned counsel for the petitioner submits that though the learned counsel for the applicants have submit that though the applicants have taken steps for issuance of notice upon remaining respondents by usual mode, however, some time may be granted to them for taking steps for issuance of notice by speed post. The prayer is allowed. The applicant shall take steps for issuance of notice by speed post on the remaining respondents within 7 days from the date of this order, returnable on 24th August, list accordingly.
Obliged, lordship.
46.
May it please your lordship. Lordship, neither AD card nor answer of notice in respect of respondent number 1 and 2 as per office note dated 9/7/26.
Who is one? 1 and 2 are claimants.
1 is the claimant,
Heard
2 is the employer.
heard Miss M. Soikia, learned counsel for the applicant. You are appearing for
Respondent number 1.
1 and 2.
2 service may be awaited, lordship.
Also heard Mr. What is your name?
R. Ali. On behalf of
R. Ali, appearing on behalf of. Be louder.
M.H. Ahmed.
M.H. Ahmed, learned counsel for respondent number 1. On perusal of the office note dated 9/7/2026, it appears that the service report in respect of notices issued to respondent number 2 and 3 are awaited.
Lordship, respondent number 1 has appeared. There is a delay of 30 days. Delay can be condoned.
Fellowship, we have no objection.
Waited. However, since respondent number 1 is the claimant, who has already appeared in this case and who does not have any objection if for condonation of the delay in this case. Hence, notice to other respondents is waived. After considering the grounds stated in the instant interlocutory application to be sufficient cause which prevented the applicant from referring the connected appeal within the prescribed period of limitation, the delay of 30 days in preferring the connected MFA is hereby condoned, and this interlocutory application is allowed. Let the connected miscellaneous first appeal be registered and listed for admission on the next after
3 weeks.
after 3 weeks on a date to be fixed by registry. List accordingly.
Obliged, Lordship. May it please your Lordship. Your Lordship,
What is this?
petitioner, here the appellant here was the previous owner of the offending vehicle, Lordship. And we have annexed with the appeal memo, we have annexed the registration certificate also.
This is a delay petition.
Yes, Lordship, I just want to place
Appeal has
background.
not been admitted.
No, Lordship, I just want to place the background, Lordship, how it has gone. Now, due to certain injuries, claimant has filed the proceeding before the tribunal and
How
actually.
much delay is there?
Lordship,
How much delay is there?
delay is, Lordship, be pleased to find that excluding the COVID part, Lordship, 1,295 days, Lordship. Para 6 of my petition, and here the
Whether
Date
claimant
is-
is there, claimant has appeared. Claimant,
claimant is the necessary party, Lordship, here.
whether respondent number 2 has appeared.
Respondent number 2 is not the claimant. Respondent number 1 is the claimant.
Whether notice. Who is appearing for 1? There is no service report in respect of respondent number 1.
You have to take steps.
You have to take steps, fresh steps. Heard Ms. T's home, learned counsel for the applicant. Also heard Ms. R.D. Majumdar appearing for respondent number 3, as well as Mr. M.U. Mandal appearing for respondent number 2. It appears that in this case, respondent number 1, who is the claimant, has not been served with the notice of this interlocutory application yet. Stop. Hence, the applicant is directed to take fresh steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order. Returnable on 24th of August. Please check.
I know. May it please your lordship. Your lordship, we have filed this appeal on the ground of compassionate family pension scheme. Your lordship, here in this case, deceased was a government employee, and as such, he is entitled for compassionate family pension scheme.
Ms. P. Bhattakur, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act has been preferred by the appellant, namely New India Assurance Company Limited, impugning the judgment and award dated 11/12/2023, passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, Gauhati in MSC case number 90/2019. Whereby the present appellant was directed to pay a compensation amount of rupees 54,69,739 along with interest to the claimants. So I have gone through the grounds stated in the memo of appeal and considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th of August. Let also the records of MSC case number 90/2019 be called for from the concerned tribunal. Registry to take steps for requisitioning the records. List accordingly. In the IA,
Lordship, there is an I for stay. Your lordship, at this stage, we shall deposit 25% of the awarded amount, your lordship.
was it 50%?
No, your lordship, since our contention is that there is no loss of dependency, since the claimants are already getting 100% of the last on salary, your lordship. So the question of,
Then we'll issue notice now. At this stage, no stay.
we can deposit 25%, your
No,
lordship. at this
let
stage.
let them appear. Heard नाम लिखे वो P. Bhattakur, issue notice same as the appeal on Chitu is same date.
Obliged.
May it please your lordship, in this matter, the opposite party has filed their affidavit. On last occasion, we seek some time to file a reply because they are relying on some new facts that were not a part of the original suit.
This is against some
Injunction.
injunction order.
Yes.
Injunction was granted or refused.
Earlier injunction was refused. Subsequently, the Honorable High Court has given interim reading
In this appeal,
in this. And here the fact is that recovery certificate is issued by the Debt Recovery Tribunal Gauhati.
okay, we'll admit this appeal and list it for hearing.
If there is interim order, so a date may be fixed.
No, we'll fix whether records would be necessary. No.
It is not necessary because here the case is that he has filed petition before the Debt Recovery Tribunal under Service Act that was rejected. And there is a recovery certificate against him. Against that, there is no appeal. So only to stop the recovery proceeding, to save his another property, he has filed the present application.
Your lordship, the facts are a little more complicated if
It is not
you're willing.
complicated, it is very
It is
much clear.
complicated because there are two sale deeds. two sale deeds, one is deposited with them and the other is not deposited. For the the loan against which the sale deeds were deposited, that is with them, but the other one is not. That they are not disputing, Your Lordship. I am only on the aspect that the sale deed which is not deposited against the property, which is not deposited with you, that is my property. That there you cannot claim.
What happened to the suit?
Suit is pending, Your Lordship.
Suit is proceeding.
Suit is proceeding. No, so no, there is a stay.
Your
Oh, the
lordship,
suit also.
No, of the injunction order, Your Lordship.
But what happened to the suit?
Suit,
it
Your
is
Lordship,
pending.
it is pending.
It is pending.
Proceeding slowly.
And the fact is that there is a recovery certificate for amount of rupees 1 crore 91 lakhs against the petitioner. And the DRT has stated that
No, what is your prayer today?
Your lordship,
We'll fix it for hearing or fix it for final disposal.
for final disposal on admission.
Your Lordship may admit it and then fix it
No,
for hearing. That is the usual process.
It will
And-
delay the
and-
recovery proceeding in the DRT.
Your Lordship, see, Your Lordship, the facts are that they are taking over two properties
Yes, sir, we
on the
we are
pretext
entitled.
of
Heard.
taking one property.
Heard, Mr. What is your name?
See, Gogo, Your Lordship.
He Gogoi, learned counsel for the appellant. Also heard Mr.
A Parvez.
A. Parvez, learned counsel for the respondent. How many respondents are there?
There are 4 parties, but all are bank officials.
So you are representing the bank
Yes, ma'am.
respondents. It is submitted by learned counsel for the respondent that matter may be finally disposed of at admission stage on the next date fixed. The prayer is allowed. Let this matter be listed for hearing, for admission hearing on 5th of August.
Your Lordship, in the meantime, we may be given liberty to file a short reply against their objection.
In the interlocutory application.
In the IA. They have filed an objection in the IA. So
Okay.
there are certain facts that we need to dispute.
In the IA. Same. Heard so and so. Learned counsel for the opposite party / appellant has prayed for allowing the whose IA is this? Who has
We had filed the IA for stay.
learned counsel for the applicant has prayed for allowing the applicant to file reply against the objection filed by the respondent in this interlocutory application. The prayer is allowed. They may do so before the next date fix, as on the next date endeavor shall be made to dispose of the connected first appeal against order.
Your Lordship,
Let this matter be listed.
this one, they have filed objection in both the FAO and the IA. So we'll be filing objection in both.
You may file.
Yes.
Let this matter be listed again on 5th of August.
Your Lordship, interim order.
The interim order shall continue till next day.
Much of it.
Anything?
Lordship, this item number 10, the appellant has died, Lordship. So I need to file application with substitute his wife. It may be shown. In the meantime, I'll file the application now to substitute his wife.
Item number 10. Heard Mr. F.Z. Mazumdar, learned counsel for the appellant who submits that as appellant has expired, he may be granted some time to take appropriate steps for substituting the legal heirs of the deceased appellant. The prayer is allowed. Let this matter be listed on 26 August. Yes.
Lordship, in this matter, we have lost the records. We have lost our file while shifting of the chamber, Lordship may kindly allow us to take photocopy of memo of appeal along with all the annexures from registry.
Heard Miss D. Hajorika, learned counsel for the appellant. Why it is registered after so many years? It was filed in the year 2014,
Yes, Lordship.
but it was registered in this year, 2026, after 12 years. Why? You cannot say because you don't. Okay. Kalika. Who submits that during shifting of their chamber, they have lost the brief of the instant case. Hence, praise for allowing to take photocopies of the records, photocopies of the memo of appeal and the annexures from the record of the court, and praise that registry may be accordingly directed. Considering the submission the prayer is allowed, the registry is directed to furnish copy of memo of appeal and annexures to the learned counsel for the appellant and list this matter again for admission on 28th August.
Item 7. May I please your lordship?
Yes.
Your lordship, this is a belated claim application filed before the Nagaon tribunal. And accordingly, my delay petition was dismissed.
Where is the memo of appeal? Okay. This heard Mr. D. Mondal learned
May I
counsel.
please your lordship?
Yes.
In terms of order passed by this honorable court, in CRP IO number 111/24, para 78.
Yes.
This claim application has to be, the order has to be set aside, and the learned tribunal has to be directed to register a miss case. In case of belated claim, the jurisdictional tribunal have the authority to register it as a miss case on a report submitted before the concerned tribunal, jurisdictional tribunal.
Where is that?
Order, your lordship, the copy I don't have the copy, but I have downloaded it.
How long is the judgment?
93 page. 93.
Okay.
My learned friend is not
Okay, you
appearing.
give this. Whether respondent side has appeared? No.
Other side have appeared on the
But
last
this is
occasion,
the-
delay was condoned. And today also their name has been reflected.
You issue note. We will admit the appeal.
P. Hajarika. His name has been shown. On last occasion also he have said the similar thing which I am today submitting. That this case should be remanded back to the.
But let him appear.
Let it short date may be fixed on that day.
Mr. Dima, you notify him
Your lordship, it may be fixed for final disposal.
No, but notice has to, his
No,
presence is not shown in the record,
no, your lordship, in the delay application, he appeared.
but here.
Today also, his name has been reflected in the cause list.
Okay.
Your lordship may fix a short date. I will personally inform him.
Heard Mr. D. Monroe, learned counsel for the appellant. This appeal under section 173 of Motor Vehicle Act 1988 has been filed by the appellant impugning the order dated 7/6/2023 passed by the Motor Accident Claims Tribunal now in this case number 22/2022, whereby the claim case filed by the present applicant was dismissed on the ground of limitation. This appeal. I have perused the grounds taken in the memo of appeal. This appeal is admitted. Let the notice be issued to the respondents. For 1 and 2,
Yes, your lordship.
issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 14th, returnable on 17th, 24th August.
Highly obliged.
Yes, Your Honor.
Lordship, this is a statutory appeal, Lordship. You are challenging the quantum of compensation. The case was filed under 163A, but learned tribunal had added 40% future prosperity. In the 163A, there is no provision for such addition, Lordship. So quantum is in the higher side, Lordship. So we have challenged the judgment.
Heard Mr. A.J. Sakya, learned counsel for the appellant. Also heard Mr. A. Agarwal, appearing for respondent number. Sole respondent.
claimant, only one.
There are two opposite parties, Lordship. We will take step on respondent note.
Respondent number 1. This appeal under section 173 of the Motor Vehicles Act has been preferred by the appellant insurance company, impugning the judgment and award dated 10/11/2025 passed by the Motor Accident Claims Tribunal, Gwalpara, in MEC case number 256/2018. The appellant is mainly aggrieved with the quantum of compensation awarded to the claimant respondent. Issue notice to the respondent and call for the records of MEC case number 256/2018 from the concerned tribunal. The appellant shall take steps for issuance of notice against respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th of August.
Extra copy may be served.
Since Mr. A. Agarwala has already appeared for respondent number 1, no formal notice need to be issued to the said respondent, however, the copy of memo of appeal along with annexures shall be furnished to him within 2 days from the date of this order. Let also records of the registry shall take steps for requisitioning the records of MEC case number 256/. 2018. List this matter again. 24th August. Why is there?
State also.
Pay 50%.
We have praying lordship for payment of rupees 5 lakhs, lordship.
How much is the quantum?
Total amount is 6,67,333. And there is only one claimant, lordship, wife of the deceased. Future, they are challenging
We
the
are
future,
entitled-
future prospect, they are challenging, lordship.
How much is the future prospect?
40% is added, lordship.
1 lakh something, lordship.
How much it comes?
Sorry.
Then you can pay more than 50%.
Lordship, they are entitled to interest also, so 4 lakhs we are paying. 4 lakhs. Yeah, otherwise 3,33,000, 50%. 4 lakhs lordship.
We are praying for 5 lakhs. lordship.
Take 4 lakhs. They are ready to pay. Heard Mr. A.J. Saikya. Learned,
Claimant may be allowed to withdraw, lordship, without any right.
heard Mr. A.J. Saikya, learned counsel for the applicant. Also heard Mr. A. Agarwala, learned counsel for the respondent / claimant. This interlocutory application under Order 41, Rule 5 of the Code of Civil Procedure has been preferred in connection with MAC Appeal number 182/2026 by the applicant / appellant insurance company, praying for stay of execution of the judgment and award dated 10/11/2025, passed in MAC case number 256/2018 by the Motor Accident Claims Tribunal, Gwalpara, during the pendency of the conducted MAC appeal number 182/2026. Mr. A. Agarwala, learned counsel for the claimant respondent, submits that the claimant respondent does not have any objection to the prayer made by the applicant, subject to the condition that they pay rupees 5 lakhs in interim as a condition for stay of the impugned judgment and award. However, learned counsel for the applicant / insurance company is submits that the 50% of the awarded amount comes to rupees 3,30,000. However, the insurance company is ready to deposit rupees 4 lakhs as a condition for grant of stay of the impugned judgment and award. After considering the submissions made by learned counsel for the parties and after going through the materials available on record, this interlocutory application is allowed, subject to deposit of rupees 4 lakhs out of the awarded amount by the applicant insurance company before the registry of this court, within 6 weeks from the date of this order, as a condition for grant of stay of the execution of the impugned judgment and award. Stop. If the applicant insurance company deposit the said amount before the registry as directed by this court, same shall be disbursed by the registry to the respondent number 1 / claimant, namely Aibana Marak, after proper verification.
Without any rider, lordship.
Stop. This interlocutory application is accordingly disbursed.
I put the decrease to without any fixing, 1 lakh currently met fixing. So without any fixing.
What was directed by the
1,50,000 was directed as a fixed deposit, lordship. So we are paying for without any rider because there is sole claimant, wife of the deceased.
Okay, without any rider. Stop. Last made. This interlocutory application is accordingly disposed of.
Lordship, in the main appeal, my name is not shown, Lordship. My name may be shown in the main appeal.
Main appeal, name of Mr. A.J. Soikya may be reflected in the cause list as the engaged counsel for the appellant henceforth.
May I please be Lordship? Lordship, this appeal is for enhancement of compensation. So the appeal may kindly be admitted, Lordship.
Heard Mr. A.R. Agarwala, learned counsel for the appellant. Also heard Ms. M. Chaudhary, learned counsel for
Respondent number 1, Lordship.
respondent number 1. This appeal under section 173 of the Motor Vehicles Act has been filed by the appellants / claimants impugning the judgment and award dated 12/12/2022 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, Gauhati in MAC case number 207/2020. The appellants are basically aggrieved with the quantum of compensation awarded to them by the Motor Accident Claims Tribunal stuff. I have gone through the grounds stated in memo of appeal stuff. This appeal is admitted. Let the notice be issued to the respondents. Let the records of MAC case number 207/2020 be called for from the concerned tribunal. Since Ms. M. Chaudhary has already appeared for respondent number 1, no steps needs to be taken for issuance of notice to said respondent. However, you have received the memo of appeal.
Yes, Lordship. Listen.
Stop. However, as regards the other respondents, the petitioner shall take steps
Take by speed post, Lordship.
by speed post within 7 days from the date of this order, returnable on 26th August, list accordingly.
Obliged, Lordship.
Item 11.
Lordship, my name has not been reflected in the cause list. My learned friend has informed me over phone just a while back, Lordship.
No, in the meantime, my lord, he has to serve the court with memo of appeal. A fixed date, my lord.
Heard Mr. M.M. Zaman,
Then
learned counsel for the appellant. Also heard Mr. R.C. Paul,
respondent number 1.
learned counsel for respondent number 1. This appeal under section 173 of the Motor Vehicles Act has been preferred by the appellant.
For enhancement.
For enhancement. Lordship.
Appellants impugning the judgment and award dated 25/4/2024 passed by the Motor Accident Claims Tribunal, Gauhati in MAC case number 305/2017. The appellants / claimants are basically aggrieved with the quantum of compensation awarded to them and are praying for enhancement of the same in the instant appeal. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MAC case number 305/2017 be called for from the concerned tribunal. Registry to take steps for requisitioning the records. Let notice be issued to the respondent. Since Mr. R.C. Paul has already appeared for respondent number 1, no steps for issuance of notice to the said respondents needs to be taken. However, the appellant is directed to furnish copies of memo of appeal along with annexures to the learned counsel for respondent number 1 within 2 days from the date of this order. As regards other respondents, the appellants shall.
Respondent lordship.
There are other respondents also. 2, 3, 3
Oh, lordship.
other
I'll take
respondents.
steps regarding the others.
The appellant shall take steps for issuance of notice upon the said respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th of August. Stop. The registry is directed to reflect the name of Mr. M. Zaman as the engaged counsel for the appellant in the cause list henceforth, list accordingly.
Obliged, lordship.
Item 12.
This is was a government employee, and he died after notification issued by the government regarding compassionate family pension. So deposit 20% of the award. 20% and that may be released subject to a bond also. Total award was around 56 lakhs. 57. 57, 80 lakhs.
Only less than 6 months service only. And the peak hours he died, lordship. And there is honorable Gauhati High Court judgment also that future prospects and
that is why 20% also.
Conventional heads and future prospects should be paid.
How much it comes?
It comes in around 20 lakhs, lordship. So if 20 lakhs paid, lordship, then
20 lakhs is, what is the
award was
Total 57 lakhs. So 20% is the same, approximately same.
no, lordship. That comes around 11 lakhs like that. But here is future prospect is
Future prospect has been assessed at rupees
15 lakhs something.
18 lakhs 87.
18 lakhs. 18 lakhs and the conventional heads 1,25,000 like that.
We can deposit lordship that amount, but subject to a bond lordship, and 15 lakhs may be released.
No, lordship, the whole amount, lordship, it comes around 18 lakhs 87,488, lordship. My humble submission 20 lakhs.
if it 18 lakhs, 18th,
18 lakhs 87,488.
488.
then you deposit 19 lakhs. Heard Mr. S.K. Goswami, learned counsel for the appellant. Also heard Mr. A.R. Agarwala, learned counsel for the respondent. This appeal under Section 173 of the Motor Vehicles Act 1988 has been filed by the Oriental Insurance Company Limited, impugning the judgment and award dated 29/10/2025, passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, in MAC case number 1079/2021, whereby the appellant insurance company was directed to pay a compensation amount of rupees 57,83,464, along with an interest at the rate of how much?
Interest is
7
6%. Page 26.
At the rate of 6% thereon. I have gone through the grounds taken in the memo of appeal and have considered the submissions made by learned
There is no interest on future prospect also,
counsel.
as per order.
But as per
Learned
also
counsel.
guidelines, interest is there in the future. Now,
There is no guideline.
no, judgment, lordship.
In a judgment, there
Yes, yes. Future prospect interest should be paid.
Earlier full bench judgment of the Honorable
can.
Court as well.
made by learned counsel for the appellant. This appeal is admitted. Let the records of MAC case number 1079/2021 be called for from the concerned tribunal. The registry to take steps for requisitioning the records. Let the notice be issued to the respondents. Since Mr. A.R. Agarwala has appeared for respondent number 1 and 2.
Claimant 1, 2.
Both 1 and 2. No formal notice need to be issued to the said respondent.
Extra copy.
However, the appellant is directed to furnish requisite number of copies of memo of appeal along with annexures.
Already provided.
One extra.
This is the caveat it was provided,
Ah,
but extra copy I mentioned, we will two claimants there.
I can give lots extra, one copy, I can give lots.
It's not that may can be recorded.
Furnished to the learned counsel for the appellant within 2 days from the date of this order. However, stop. As regards the other respondents, the appellant shall take steps for issuance of notice upon the said respondent within 7 days from the date of this order by speed post as well as by usual mode, returnable on 26th August, list accordingly. In IA, this interlocutory application has been filed by the applicant, namely Oriental Insurance Company Limited, in connection with Merck Appeal number 273/2026, praying for stay of execution of judgment and award dated 29/10/2025, passed by Motor Accident Claims Tribunal number 1, Kamrup Metro, Gauhati in MEC case number 1079/2021 during the pendency of the connected Merck appeal. Stop. Learned counsel for the claimant respondent, Mr. A.R. Agarwal, has submitted that the respondent claimant does not have any objection to the plea if the applicant deposit an amount of rupees 20 lakhs as a condition for grant of stay of the execution of the impugned judgment. On the other hand, learned counsel for the applicant submits that since in view of the contention raised by the present applicant in the connected appeal, the claimant may be admittedly entitled to the compensation granted to them against conventional heads and against future prospects, which comes roughly to 18 lakh 87,480. The insurance company is ready to deposit the said amount as a condition for grant of stay. Stop. After considering the submissions made by learned counsel for both sides, and after going through the materials available on record, this interlocutory application is allowed, and the execution of the impugned judgment and award is stayed subject to deposit of an amount of rupees 19 lakhs out of the awarded amount, out of the awarded compensation to the claimant respondent before the registry of this court within a period of 6 weeks of the date of this order. Stop. In the event the said amount is deposited by the
Number 1, 2.
insurance company,
Without this
same may be disbursed.
They are coming only for quantum.
So bond, I think, mostly.
Same may be due. Same may be.
They are paying only future prospects and the consortium
Maybe
heads.
file an application.
No. Then bond is not.
Same may be disbursed to the respondent claimants
1 and 2.
One and two.
number 1 and 2 after proper verification.
Without any right and lordship. Without because
Stop. Full
both
stop.
survived.
Full stop. This interlocutory application is accordingly disposed of.
Publish.
Made previous your lordship. Basically, the appeal is on quantum lordship because the claimant herself in cross-examination said that accident took place due to her fault and the amount future treatment is given and some treatment were not taken for the accident. Those amounts were also given. So lordship.
Third Miss Hardy Majumdar, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 28/12/2023 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MAC case number 1902/2019, whereby the present appellant was directed to pay a compensation amount of rupees 11,32,310 along with an interest at the rate of 9% per annum to the respondent/claimant. Stop. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. Stop. This appeal is admitted. Let the notice be issued to the respondents.
May I submit something on notice? For respondent number 1, someone is appearing, name is also shown. I'll give them the copy. 2 and 3 lordships, they may be waived because they are not necessary. It is on quantum and unnecessarily the case will be pending for service.
Learned counsel for the appellant submits that since name of a counsel of
It appeared in delay petition lordship. There was a delay.
since respondent number 1 was represented in the connected interlocutory application by his engaged counsel, by her engaged counsel, instead of issuance of notice to the respondent number 1, the appellant may be allowed to serve the notice on the engaged counsel for respondent number 1. Same is allowed. Stop. Same is allowed. Stop. The learned counsel for the appellant also submits that since this appeal is basically directed against the quantum of compensation awarded to the claimant, the presence of owner and driver of the offending vehicle may not be necessary. Hence, notice to the respondent number 2 and 3 may be waived. The prayer is allowed. Let the records of MAC case number 1902/2019 be called for from the concerned tribunal. List this matter again on 28th August.
Highly obliged lordship.
Heard Mr. K.K. Bhatta, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act has been preferred by the appellant, namely New India Assurance Company Limited, impugning the judgment and award dated 13/9/2023 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro in MSC case number 26101/2018, whereby the appellant was directed to pay a compensation amount of rupees 88,77,639, along with an interest at the rate of 9% per annum to the respondent/claimant. I have gone through the memo of appeal, grounds taken in the memo of appeal, as well as considered the submissions made by learned counsel for the appellant. Stop. This appeal is admitted. Let the records of MSC case number 2601/2018 be called for from the concerned tribunal. The registry to take steps for
So respondent number 1, 2, 3 has already appeared also.
requisitioning the
Their name has been reflected in the cause list also.
records. Since name of the engaged counsel for the respondent number 1, 2, and 3 have been reflected in the cause list, the appellant is directed to furnish, directed to serve the notice along with memo of appeal and annexures on the engaged counsel. You have served the copy?
No, not so. Delay petition will start proceed, appeal, I will serve.
Serve the copy of memo of appeal. Notice, memo of appeal along with annexures to the engaged counsel for respondent number 1, 2, and 3 within 7 days from the date of this order. Let this matter be listed again. 26 seconds. Yes.
Let's see, in this case also we'll deposit future prospect amount, let's see.
No, we issue notice. Let them appear. Let him be present when I may issue notice. On next day we'll do.
Made please, Your Lordship. Oh, this is an appeal under Order 41 Rule 1 are rejecting my application praying for temporary injunction. Well, the facts of the case is like this, Malad. The defend number 4, Malad, is a private limited company, Malad.
After final hearing.
After final hearing.
Fine.
Whereas, Malad, the learned trial court did not decide the 3 principles, golden principles, and has arrived at a conclusion since there is a bar under section 34 of the SURFACE Act and there is an remedy under the Act. Therefore, the court did not interfere with the order which has been put to challenge. Now, my lord, the prima facie, my lord, this is the case, my lord, where the plaintiff has sought for a declaration seeking that the personal guarantee which was shown to be executed by the plaintiff is a fraudulent one and executed by his fourth signature. And the subsequent mortgage letter and the confirmation of title deeds and the title deeds, which is in favor of the plaintiff, in the name of the plaintiff, are forged. And there is a criminal case instituted where there is a charge sheet, and in the forensic it has been proved. It has been proved that the signature doesn't belong to the plaintiff, my lord. So, my lord, there was a prima facie case, my lord. Initially when the suit was filed, no injunction was prayed for, because since the bank did not undertake any exercise of taking possession. Now, during the pendency of the suit, bank issued a notice for taking over possession of the suit property and for auction sale. The learned trial court initially, by way of an ad interim injunction, protected it. However, after hearing, though my lord, the bank did not file any objection, their verbal objection was that the mortgage was lawfully created. And the learned trial court arrived at a conclusion, since under section 34, under the SURFACE Act, there is a bar, the jurisdiction of the civil court has been excluded, and therefore there cannot be an injunction. Now, your lordship knows there are judgment of this court as well as the apex court, my lord, where it is said that the section 34 SURFACE Act does not act as an exclusive bar. If the suit if the subject matter of the suit relates to fraud, since the tribunal do not have the competence to decide an issue of fraud, therefore the civil court will have jurisdiction.
Now, what is the status of that surfacing method?
My lord,
Status of
that letter is still there. They have not withdrawn it.
have they done anything?
My lord, the letter says that they will take over possession, or I was asked to hand over possession.
When? By when?
It was prior when the ad interim injunction was granted.
Thereafter, nothing has
Thereafter,
been.
nothing. So, my lord, what I'm
Now we'll issue notice.
at this stage, my lord, what I'm praying for, my lord, let there be a status quo, my lord, since the subject matter, because if the auction sale is proceeded, my lord, or if the possession is granted, I'll be dispossessed. My lord, I am not the only one, my lord. My sister, who is not a borrower, who is not a guarantor, it's a joint property which we have inherited from our father. Now, interestingly, if your lordship will see, my lord, my title deed is the sale deed that is in the name of the father.
Heard Mr. B. Kaushik, learned counsel for the appellant. This appeal under Order 43, Rule 1, within bracket small r of the Code of Civil Procedure 1908 has been preferred by the appellants, impugning the order dated 28/4/2026 passed by the Court of Learned Civil Judge Senior Division Sonitpur, Tejpur in Ms. J case number 77/2024 arising out of title suit number 37/2022, whereby the prayer for ad interim injunction or
Temporary.
temporary
Temporary.
injunction. Prayer for grant of temporary injunction was rejected by the trial court. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th August. List accordingly. Whether
26th
record
August.
26th August.
Fine.
List accordingly. I heard Mr. B. Kaushik, learned counsel for the applicant. This application under Order 39 Rule 1 and 2 of the Code of Civil Procedure 1908 has been filed by the applicant/appellant in connection with FAO number 44/2026, praying for grant of temporary injunction in respect of the suit property during the pendency of the connected FAO. Stop. Let the notice be issued to the respondents. The applicant shall take steps for issuance of notice to the respondents by speed post as well as by usual mode within 24 hours of this order, returnable on 26th of August. Stop. In the meanwhile, considering the averments made in the instant interlocutory application as well as submissions made by learned counsel for the petitioner, the respondent shall maintain status quo in respect of the suit property till next returnable date.
I'm highly grateful.
List account.
Highly grateful.